Thank you, Inka. Thank you very much. These distinguished participants in the seminar, it's a great pleasure to be with you here today. I would like to extend my sincere thanks to Heuni for inviting me to open the ReJust project's final seminar. Yes, I'm really in charge of National Prosecution Authority, and this is an organization with just shy of 600 employers. And I also serve as the nation's highest prosecutor. So in addition to my managerial duties, I take part in the concrete day-to-day work of prosecution. I have the sole power to consider charges of offenses against freedom of speech and terrorist offenses. Even though I decide whether to bring charges in such matters, I do not have time to prosecute the cases personally in the courts, but appoint a prosecutor to see to this part of the process. In any case, I'm familiar with the stages of criminal procedure and am aware of the need to improve the position of victim in criminal procedure. Well, one area of the ReJust project was to develop practical tools for operators in criminal justice system, in particular for encountering traumatized victims. As part of the project, Finnish prosecutors were trained in taking trauma into consideration in their work. International treaties and EU instruments require authorities who encounter victims in course of their duties to be trained in encountering victims and taking their needs into account. Such training is challenging for the prosecution service to arrange with its own resources, as the expertise of prosecutors lies in the fields of criminal justice and the criminal procedure. We are thus very grateful to Heuni for providing us with training on encountering victims. The prosecutors felt that the trauma training cut to the very core of their work. In crimes committed against individuals, the injured party's account usually forms a key part of the evidence. According to the Supreme Court's ruling practice, even a reliable account by the injured party is normally not enough to secure a conviction by itself. But an injured party's account can constitute sufficiently convincing evidence for a conviction, even though supporting indirect evidence in some cases. Such cases require an even more careful assessment of the injured party's account than usually. Accounts' reliability and accuracy should be verified with other acceptable criteria. The credibility of the individual cannot be granted any great significance in the assessment of the reliability of personal evidence. More significant considerations include the reliability of the account. Here we encounter the key problem that memories are stored differently during traumatic events. The brain does not store memories in chronological order. There are gaps in memory, and the traumatized person may only remember unimportant details of the event. A traumatized person may be unable to give a consistent, detailed account or to distinguish between the relevant and the irrelevant. They may not be able to speak about the trauma at all. Here I was quoting from Heuni materials what I got from the prosecutors from this training session. How can the prosecutor act to get account from the injured party that is reliable by the standards of Supreme Court? Trauma-informed encounters can be one solution to this dilemma. In their feedback, the special prosecutors said that, in particular, the training gave them tools for considering what kind of questions should be asked from traumatized people in the courtroom, and how to ask them in order to get the most coherent and detailed account without traumatizing the victim any further. In this regard, prosecutors' comments also raised doubts about whether it was possible for prosecutors to work in trauma-informed manner while maintaining objectivity. The prosecutor's comments highlighted a need for expert statements on the effects of trauma on memory and the victim's account, especially its reliability. For children, prosecutors have access to various statements by the Family Federation of Finland and Helsinki University Hospital, but there are not such statements available for adults. The idea of the material bank that could be invoked in trials was a recurring theme in the feedback. If such a resource was available, information on the effects of trauma on the actions and memory of victims would not be limited to the prosecutor's words in court anymore. In the discussions during the trauma training, many prosecutors spoke about their difficulties in coping with the serious subjects that come up in their work. The chronic lack of resources in aggravating this issue. Some prosecutors also asked how they could encounter the victim in a sufficiently trauma-informed manner, yet without giving too much room for their own emotions. How can the prosecutors be protected from secondary traumatic stress? Counseling is especially important when the work involves difficult subjects. National Prosecution Authority has organized counseling to support its prosecutors' availability to cope with their work. Two types of on-the-job counseling have been provided in recent years. Counseling for special prosecutors for sex offenses and counseling related to coping with the work of a prosecutor. The general counseling was given in group sessions, while special prosecutors also had the opportunity for individual counseling. The purpose of the counseling was to prevent the realization of psychosocial risks involved in the work of prosecutors. It has also been our aim to establish permanent nationwide counseling practices in the National Prosecution Authority. This brings me to my last point. Even before the trauma training provided by HONI, National Prosecution Authority had organized training related to domestic abuse and human trafficking. Training on these subjects will continue. We also hope to have the opportunity to participate in training organized by our stakeholders. Prosecutors are usually the most specialized people in the courtroom. Taking trauma into consideration cannot be left on their shoulders. Indeed, National Prosecution Authority expresses the emphatic wish that trauma training be organized for judges and legal counsels as well. Legal counsel have the most important role to play in preparing the victim for the stressful hearing and supporting them during it. Ignorance of the effects of trauma on the injured party's account can lead to false convictions or failure to hold the hearing in a trauma-informed manner. For example, the victim may not be given opportunity to be heard over the video connection if the traumatized person's need for special protection is not recognized. So the joint training for prosecutors, legal counsel, and judges would also be an option. Such training could help these practical actors see the significance of trauma more widely than through the lens of their own specialized roles. It would have the greatest positive impact on both the progress of the criminal procedure and preventing the re-traumatization of the victim. Finally, I would like to say that Rejust project has been an evident success. On behalf of National Prosecution Authority, I extend my heartfelt thanks to everyone who contributed to it. I wish you all fruitful and successful seminar, and I apologize that I'm not able to continue with you because on other occasion. So thank you very much for your time and have a successful seminar.